Good evening, everyone. A very warm welcome to today's special webinar hosted by LiveLaw Academy. I, Kritika Goyal, am delighted to see so many aspiring legal minds with us this evening. Now, before we begin, it is both my honor and privilege to introduce the guiding force behind today's session, Justice V. Ramkumar, sir, our patron and chief mentor at LiveLaw Academy. Welcome, sir.
Thank you.
Justice Ramkumar is a distinguished former judge of the High Court of Kerala. Sir began his legal journey with LLB from Government Law College, Mumbai, and enrolled as an advocate in 1979. In 1987, Sir was directly recruited as a district and sessions judge. Sir later served as law secretary to Government of Kerala and was appointed as a permanent judge of the Kerala High Court in 2004, a position Sir held until his retirement in 2012. Sir has served as the chairman of the advisory board under the Kerala Anti-Social Activities Prevention Act and also the ombudsman for Kerala Cricket Association. Justice Ramkumar sir is frequently invited by judicial academies, law universities, and the Bar Council to share his insights with judicial officers, public prosecutors, and law students alike. Sir is the author of several widely respected books, including Law of Prevention of Corruption, Tendering Pardon to an Accomplice, and Magistrate Trials, Law and Procedure. Sir has also written numerous legal articles for LiveLaw in a unique question and answer format that has helped simplify complex topics for students and practitioners across the country. Without further ado, let's all welcome Justice Ramkumar sir today. Thank you, sir.
Thank you, Kritika.
So shall we begin with the question and answers?
Oh, yes. You can begin with question number 1.
Yes, I'll just share my screen so that everyone can also read the questions and they have an idea where we are.
Okay.
So question number 1 we have, offences under the Bharatiya Nyaya Sanhita 2023, BNS for short, which has replaced the Indian Penal Code 1860, IPC for short, has been categorized into cognizable offences and non-cognizable offences by the Bharatiya Nagrik Suraksha Sanhita 2023, corresponding to CRPC. Where exactly do you find this categorization? So I'd like to answer and say that we find this categorization in CRPC or BNS in the first schedule, in the first table. And I think, so we can also find this categorization in IPC or BNS under the offense, the punishable section under that.
Yes, but then you won't find it in the IPC or BS, but only in the CRPC or BNSS. For schedule, first schedule, there are 6 columns altogether. 6 columns. In that 4th column, column number 4, shows every offense. First schedule has got 2 parts. Part 1, dealing with all the offences under the BNS, Bharatiya Nyaya Sanhita, and that is IPC. And part 2 deals with offences under other laws. Now, part 1, column 4, shows every offences under the BNS as either cognizable or non-cognizable. So, to find out whether a particular offence alleged is cognizable or non-cognizable, you have to look into column 4 of the first schedule, part 1 of the first schedule to BNSS. Now, supposing, now we go to the next question. When we go to the next question, you will find out that answer.
Yes, sir. So question number 2, supposing the offences alleged are not punishable under the BNS, that is IPC, but are punishable under another penal statute, which does not state whether the offence thereunder are cognizable or non-cognizable, then how to find out whether the alleged offence is cognizable or non-cognizable?
As I told you, part 1 of BNS describes all the offences. Part 1 of BNSS, that is CRPC. First schedule, part 1 of BNSS describes all the offences under BNS, that is formerly IPC. And part 2 describes, it does not describe the offences. Part 2 gives a guideline for finding out whether offences under other laws are either cognizable or non-cognizable. The three tests are: if the alleged offence is 1, punishable with death, imprisonment for life, or imprisonment for more than 7 years, then the offence is cognizable. You have to take it that the offence is cognizable and non-bailable and triable by a court of session. This much information is given in part 2 of first schedule. Then second test is, if the offence is punishable with imprisonment for 3 years and upwards, 3 years and upwards, but not more than 7 years, then the offence is cognizable, non-bailable, and triable by a magistrate of the first class. So if it is above 3 years, in every case, it is cognizable. So offence is cognizable under any law. Now, third test is, if the offence is punishable with imprisonment for less than 3 years or with fine only, less than 3 years or with fine only, then the offence is non-cognizable. It should be treated as non-cognizable, bailable, and triable by any magistrate. So if the offences are not under BNS, that is IPC, but under any other law, then you apply these three tests to find out whether the offence, because there are some special laws which only gives the punishment. It does not say whether the offence under this, ordinary, there are some laws, some statutes which say that all the offences under chapter 3 shall be deemed to be cognizable. Even though applying this test, it may not be cognizable. But if the statute says that all the offences shall be deemed to be cognizable, then it has to be treated as cognizable. But if there is no such provision in the special statute, then you apply this part 2 of the first schedule to BNSS to find out whether the offence is cognizable or not. These are the three tests to be applied. Am I clear?
Yes, sir.
Okay.
For everyone, they can also write clear in the chat box,
okay,
if they all get it.
Question number 3.
Question number 3. What is a cognizable offence?
Section 2(1)(g) of BNSS is corresponding to section 2(c) of CRPC, which has been repealed. Cognizable offence means an offence for which a police officer may arrest the offender without a warrant. If it is a cognizable offence, police officer can straightaway arrest him without the warrant of a magistrate, or arrest warrant of a magistrate. That is the cognizable offence. So how to find out cognizable offence? Column 4 of first schedule. Column 4 of first schedule, whether it is BNS or other laws. It is column 4. That column shows it is cognizable or non-cognizable. If it is a cognizable offence and committed to the knowledge of the station house officer in charge of a police station, he can straightaway arrest the offender without the warrant of arrest from a magistrate. That is a cognizable offence. Yes. Now, question number 4.
Question number 4. What is a non-cognizable offence?
Now, cognizable, we have seen, a police officer can arrest the offender without the warrant of a magistrate. Now, a non-cognizable offence, as per section 2(1)(o) of BNSS, corresponding to section 2(l) of CRPC, a non-cognizable offence means an offence for which a police officer has no authority at all to arrest the offender without a warrant. He shall require the warrant of a magistrate to arrest the offender, because it is comparatively minor offence. So the police officer cannot misuse his authority by arresting him straight away. He has to obtain the warrant of a magistrate. That is non-cognizable offence. So cognizable offence, without a warrant he can arrest. Non-cognizable offence he cannot arrest without a warrant. Yes. Question number 5.
So question number 5. What is the difference between a cognizable offence and a cognizable case? Made mention in the title and the body of section 173(1) of BNSS, that was section 154(1) of CRPC.
If you look at section 173(1) BNSS, the title of the section, see, I'll read it out for you. Information in cognizable cases. information in cognizable cases, not cognizable offence. The body of the section uses the expression cognizable offence, but title says information in cognizable cases. What is the difference between cognizable offence and a cognizable case? That you will, the answer to this you will find in section 174 clause 4, 174.4 of BNSS corresponding to section 155.4 of CRPC, which now stands repealed. Now this clause 4 of section 174 BNSS reads as follows. Where a case relates to two or more offences of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable. There are supposing 3 non-cognizable offences and 1 cognizable offence alleged in the information given to the officer in charge of a police station. Then you can't call all the offences cognizable. But there is 1 cognizable offence to make it a cognizable case. In that case, the police officer is bound to register an FIR because he has to treat it as a cognizable offence. That is why the distinction between cognizable offence and cognizable case is this. That is, if the case relates to 2 or more offences, of which at least 1 is a cognizable offence, the case shall be deemed to be a cognizable case, notwithstanding that all the other offences are non-cognizable. Therefore, there's enough. 1 cognizable offence is enough to make it a cognizable case. Then, in that case, it will fall under section 174.4 and it will fall under section 173.1 BNSS, obliging the SHO, Station House Officer, to mandatorily register the FIR, even though 3 of the offences are non-cognizable. Okay. I suppose it's clear for you. Am I clear?
Sir. Yes, sir. Okay. Crystal clear.
Thank you.
I request everyone present to also write clear or okay or thumbs up in the chat box if it's clear. Or if you have a doubt, you can mention that as well.
Yes.
So question number 6.
Yes.
The information given to the officer in charge of a police station, SHO, clearly makes out a non-cognizable offence. Applying the ratio laid down in Lalita Kumari versus Government of UP 2014 to SCC 1, is not the SHO bound to register an FIR and investigate?
Yes.
Can I try and answer this?
Please, please.
So if it's a clear case of a non-cognizable offence, then he's not bound to register an FIR. So
you are right. You are absolutely right. You are absolutely right, Kritika. No, mandatory obligation of the SHO to register an FIR is only on receiving information regarding a cognizable offence or a cognizable case. Cognizable case is one offence would be cognizable offence. Even though all the other offences are non-cognizable. So it should be either a cognizable offence or at least a cognizable case for the SHO to compulsorily register an FIR. He has no option, no choice. He has to register an FIR. But if the offence alleged is a non-cognizable offence only, or all the offences are non-cognizable, then he has no jurisdiction to register an FIR or conduct investigation. That is you may under 154 CRPC corresponding to section 173.1 BNSS, you will find that the SHO should register an FIR only if he receives information regarding a cognizable offence or a cognizable case, not otherwise. So you are absolutely right, Kritika. The SHO has no duty at all to register an FIR. Yes, question number 7.
Question number 7. If the SHO cannot register the FIR or conduct investigation on receipt of information, that is FIR, relating to a non-cognizable offence, will it be possible for him to investigate such an offence?
See, a person, non-cognizable offence is also an offence. It is also an offence, and of course, though a minor offence, it is also an offence under the BNS, Indian Penal Code, or falling under first schedule to BNSS or CRPC. So every person, a person who comes to the SHO alleging the commission of a non-cognizable offence also should have some relief. But the section says the SHO is bound to register an FIR only if the allegation is of a cognizable case or a cognizable offence. Here it is a non-cognizable offence. What is the way out? Now, he will have the power to register an FIR, investigate, provided in the case of a non-cognizable offence, the SHO obtains an order from the jurisdictional magistrate under section 175(2) VNSS, that is corresponding to section 155(2) of CRPC. This subsection 2 of section 174 BNSS reads as follows. No police officer shall investigate a non-cognizable case without the order of a magistrate having power to try such case or commit the case for trial. What do you mean by that? If the allegation is a non-cognizable offence, no police officer shall investigate a non-cognizable case or offence without the order of the magistrate having the power to try such offence. That magistrate should have the power to try the offence or commit the case for trial. The case may be triable exclusively by a court of session, and the magistrate should have the power to commit that case to the court of session for trial. So there can be two situations where the magistrate can himself try the offence or can commit the case for trial. The trial may be to be conducted by the Sessions Court. There is an intervention from a dog.
So that's my pet. I'm so sorry.
Oh, sorry.
So sorry, sir.
Yeah. Yes.
Note myself. So please continue, sir.
Yes. We have that this position has been highlighted by a decision by Justice Bechu Kurian Thomas of Kerala High Court. He is the son of Justice K.T. Thomas, Bechu Kurian Thomas. Hanifa versus State of Kerala. Hanifa versus State of Kerala. 2022, 6 KLT online, 1064. 2022, 6 KLT online, 1064. That is, without the order of the jurisdictional magistrate, a police officer, an officer in charge of a police station, has no jurisdiction to investigate a non-cognizable offence. Now we pass on to question number 8.
So question number 8.
Yes.
What is the procedure for getting the order of the jurisdiction magistrate under section 174 to BNSS, yes, that is 155 yes, to CRPC?
Now we have seen that a police officer, an SHO, does not have the jurisdiction to register an FIR or conduct investigation in respect of a non-cognizable offence unless he gets an order from the magistrate, jurisdictional magistrate concerned. So he has to obtain the orders of the jurisdictional magistrate. Now, what is the procedure for getting the orders of the jurisdictional magistrate? Now, section 174(1), section 174(1) BNSS, corresponding to section 155(1) of CRPC, reads as follows. When information is given to an officer in charge of a police station of the commission within the limits of the station of a non-cognizable offence, he shall enter or cause to be entered the substance of the information in a book kept by such officer in such form as the state government may prescribe in this behalf. And clause 1, refer the informant to the magistrate. Refer the informant to the magistrate. We are concerned with clause 1 only. Thus, going by the above provision, the only option available to the SHO is to refer the informant to the magistrate. This means that it is for the informant to obtain the orders of the jurisdictional magistrate under section 174(2) of BNSS corresponding to section 155 to CRPC. Now we pass on to the next question. That means if the information given to the SHO is a non-cognizable offence, the SHO has to refer the informant to the magistrate. He has to tell the informant, Mr. Complainant, you have alleged a non-cognizable offence. I cannot register an FIR or conduct investigation without the order of the magistrate under section 174(2) of BNSS. So you please obtain the orders of the magistrate under section 174 to BNSS. So he has to do that. Now the next question will make the position clear. Please read question number 9. Kritika.
Yes, sir. So question number 9. Is it permissible for the SHO to himself approach the magistrate and obtain the order of the magistrate instead of referring the informant to the magistrate?
See, what the section says is, he shall refer the informant to the magistrate. Now our question is whether the SHO can himself approach the magistrate and obtain the orders on behalf of the informant. Section doesn't say so, but interpreting the section, a constitutional bench of 5 judges in paragraph 7 of A.R. Anthule versus R.S. Nayak, AIR 1984 Supreme Court 718, AIR 1984 Supreme Court 718, corresponding to 1984 Volume 2 SEC 500. The Constitutional Bench, speaking through Justice D.A. Desai, observed as follows. If the offence complained of is a non-cognizable one, the police officer can either direct the complainant to approach the magistrate, as the section says, or he may obtain permission of the magistrate and investigate the offence. So, interpreting that section, corresponding section in the IPC and CRPC, that is section 155(1), the Constitutional Bench observed that he may either refer the informant to the magistrate or he may himself obtain permission of the magistrate and investigate the offence. Now the same observation was repeated by a subsequent 2-judge bench of the Supreme Court in paragraph 11 of State of Gujarat versus Girish Radhakrishnan Varde. State of Gujarat versus Girish Radhakrishnan Varde. AIR 2014 Supreme Court 620. AIR 2014 Supreme Court 620, corresponding to 2014 Volume 3 SEC 659. Now you may notice that, of course, there is a one decision of the Kerala High Court, a single judge of the Kerala High Court held that without noticing the Constitutional Bench ruling and the subsequent ruling, without noticing those decisions, binding decisions, a single judge of the Kerala High Court held that when information regarding the commission of a non-cognizable offence is made to the SHO, he can only refer the complainant to the magistrate, strictly going by the section. Now, fortunately, that decision is Dr. Biju versus State of Kerala. Dr. Biju VG versus State of Kerala. 2020, Volume 5 Kerala High Court Cases, KHC 685. 2020, Volume 5 KHC 685. Fortunately, that decision was dissented to in the light of Girish Radhakrishnan Varde to the AIR 2014 Supreme Court 620, which I referred to earlier. In Ravindran VK alias Sibi versus State of Kerala, 2024, Volume 5 Kerala High Court Cases, KHC, page 22. 2024, 5 KHC, page 22, by Justice A. Badruddin of the Kerala High Court. Now, even otherwise, we are living in an era of Janamaitri police, people-friendly police. Police should be at the service of the aggrieved person. when a person beseeches a police station, the police officer in charge of the police station should be at the service of the person, service of the citizen, instead of driving him to the magistrate. And think of the situation. Supposing the police officer says, "No, this is a non-cognizable offence. I cannot investigate." You obtain the orders of the magistrate. What will the poor soul will do? What will the poor soul do? Does he have any access to the court of the magistrate? Can he enter the court of the magistrate? Can he enter even the chamber of the magistrate? The peons there or the dafedar there will send him away. No, you have no business here. So he should not, he cannot. So he will be in a very pitiable plight. So we have to see that the police officer himself approaches the magistrate and obtains the orders under section 174 to BNSS, corresponding to section 155 to CRPC. Am I clear? I suppose I am clear.
Yes, sir. Yes, sir. Absolutely clear.
Okay.
I would also request everyone to write it in the chat box. Done or clear. Write clear in the chat box if you're clear.
Question number 10.
Question number 10. After the magistrate passes an order under section 174(2) BNSS, section 155(2) CRPC, in respect of a non-cognizable offence, what is the procedure which the SHO has to follow?
Now, we have seen that if the offence alleged is a non-cognizable offence, the SHO, Station House Officer, can register an FIR and commence investigation only if there is an order passed by the jurisdictional magistrate under section 174(2) of BNSS, corresponding to section 155(2) of CRPC. Now, supposing the magistrate grants an order, either on the informant himself approaching him or by the police officer directly approaching the magistrate and getting orders, what is the procedure to be followed by the SHO? What should the SHO do next? What is the procedure? There you get the answer under section 175(3), subsection 3 of section 174, subsection 3 of section 174 BNSS, corresponding to section 155(3) of CRPC. Based on the order of the magistrate, the SHO can register the FIR and commence investigation, conduct investigation, complete the investigation, and file a police report before the magistrate, either charge sheeting the accused or filing a closure report, dropping the case in the same manner as if it is in the case of it is a cognizable offence. Just as in the case of a cognizable offence, the police officer will have to register FIR, conduct investigation, and file a charge sheet or a closure report. And if it is a closure report, he will have to give notice to the first informant, aggrieved person. This enabling provision you will find in subsection 3 of section 174, corresponding to section 155(3) CRPC. Now, after the overall position is this: if it is a cognizable offence, SHO has no freedom, no choice but to register an FIR. But if it is a cognizable case consisting of one cognizable offence at least and all others non-cognizable, then it should be treated as a cognizable case and the SHO has to mandatorily register an FIR, conduct investigation. But if all the offences or a solitary offence alleged or all the offences alleged are non-cognizable, the SHO has no jurisdiction to register an FIR or conduct investigation unless he obtains the order of the jurisdictional magistrate under section 174(2) of BNSS. Once the order of the magistrate is obtained, the SHO should proceed as if it is a cognizable case and register FIR, conduct investigation, and finally either charge sheet the accused or file a refer report or closure report. This is the procedure. I suppose I am clear. Yes. Now, question number 11.
Yes, sir. Question number 11. Supposing, acting on the information alleging the commission of a cognizable offence, the SHO conducts investigation and finds that the offence committed is really a non-cognizable offence. What will be the status of the police report filed by him with regards to such non-cognizable offence for which the order of the magistrate had not been obtained under section 174(2) BNSS or 155(2) CRPC?
Yes.
So can I try this answer?
Oh, sure.
So I think the police report will be considered as a complaint and the police officer will be considered as a complainant.
Which is the enabling provision? Under which enabling provision?
So I remember the CRPC provision, which is section 2, clause D.
Explanation. Explanation to section
of
2D.
Yes,
2D. You are right, absolutely right. And the corresponding section is explanation to section 2H. 2H of BNSS. I will read that.
Yes, sir.
Complaint, I am reading the definition of complaint under section 2H, 21H of BNSS. Complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this Sanhita that some person, whether known or unknown, has committed an offence, but does not include a police report. So a complaint cannot be a police report, and a police report cannot be a complaint. Police report is a report filed by the police after conducting an investigation under chapter 13 of BNSS, corresponding to chapter 12 of CRPC, and filing a report under section 173 to CRPC. 173 to CRPC is corresponding to 193 of BNSS. Now, that is the police report. So, complaint is not a police report. Police report is not a complaint. Now, this is the definition of a complaint. Then there is an explanation to section 2H. A report made by a police officer in a case which discloses after investigation the commission of a non-cognizable offence shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to be the complainant. So a report made by a police officer in a case which discloses after investigation. So see the wording of the explanation. When can he conduct investigation? He can conduct investigation only if it is a cognizable offence. If it is a non-cognizable offence, he has no power to conduct investigation unless he obtains the order of the magistrate. So if a police officer after investigation, means into a cognizable offence, discovers that the offence which is really committed is a non-cognizable offence, then he cannot charge sheet the accused because there was no order of the magistrate under section 174(2). Therefore, this explanation says that the report which he files shall be deemed to be a complaint, and the police officer who files the report shall be deemed to be the complainant. So, that is the situation. So, police officer, in order to conduct investigation, there should be the allegation of a cognizable offence. It's only if a cognizable offence is alleged, the police officer can commence the investigation. And after investigation, he discovers that the offence is not a cognizable offence as alleged, but it is a non-cognizable offence. Then, since there is no previous order of the magistrate under section 174(2) BNSS, the police officer cannot charge sheet the accused. The investigation was really conducted without the order of the magistrate. Therefore, the explanation enables the police officer to file his report, and there is a statutory fiction by which his report shall be deemed to be a complaint, and the police officer who filed the report shall be deemed to be a complainant. It is then the magistrate can take cognizance of the offence on that complaint, not on the police report. There can't be any police report. This is the position. I suppose I am clear.
Yes,
Now,
absolutely clear.
yes, now we pass on to another question.
So question number 12. Supposing the only offense alleged in the information is a non-cognizable offense, and the SHO, by ignorance or mistake, conducted investigation without the order of the magistrate under section 174(2) BNSS, that is 155(2) of CRPC, will not the report filed by SHO be deemed to be a complaint within the meaning of explanation 2, section 2H BNSS, that is section 2D of CRPC?
See the distinction between the earlier question and this question. Earlier question, he conducted investigation, which presupposes the allegation of a cognizable offence. In which case, then only he can register an FIR and conduct investigation. But here, even to start with, even ex facie, on the face of it, the offence alleged is a non-cognizable offence. So he has to obtain the order of the magistrate under section 174(2) BNSS to commence investigation. He has not obtained that. He conducts investigation without the order of the magistrate, and after investigation he discovers. It's not a discovery actually. Even originally it was a non-cognizable offence. He finds that the offence alleged is a non-cognizable offence. Then the question is whether that can be treated as deemed to be a complaint, and the report filed by him can be deemed to be, and the police officer who filed the report can be deemed to be a complainant. This was a question which was before the Supreme Court in Keshavalal Thakur. Keshavalal Thakur versus State of Bihar, 1996, Volume 11, SEC 557. 1996, Volume 11, SEC 557. The judges are M.K. Mukherjee and S.P. Kurdukar. Their lordships held that no, this cannot be treated as a complaint, and the police officer cannot be treated as the complainant by invoking the explanation to section 274 CRP, to section 2H of BNSS, because it originally, even at the start, it was a non-cognizable offence. It was not a cognizable offence alleged. Police officer had no jurisdiction to commence investigation without the order of the magistrate. And the magistrate, there was no order of the magistrate under section 174(2) of BNSS. So police officer was conducting investigation without any authority. In that investigation, he reiterates that the offence alleged is a non-cognizable offence. That then, since the magistrate had no the magistrate also cannot have any jurisdiction to take cognizance of the offence on such a report filed by the police officer. This case and the earlier case should be distinguished easily. The earlier case, the allegation was commission of a cognizable offence. The SHO had the right royal authority to conduct investigation. He conducted investigation. After investigation, he discovered that offence alleged is only a non-cognizable offence, not a cognizable offence as alleged in the information. That is the case. That case will come to that. In that case, the explanation to section 174 2H of explanation to section 2H of BNSS, that is corresponding to section 2D CRPC, will come to the rescue of the SHO. But in this present case, question number 12, the offence to start with was a non-cognizable offence. He had no jurisdiction to conduct investigation without the order of the magistrate under section 174(2) BNSS. Therefore, his investigation is null and void, without jurisdiction. And if he has filed a report, that report cannot be looked into by the magistrate for the purpose of taking cognizance of the offence. This is the distinction between earlier question and this question. I suppose it is clear for you. Is it clear? Am I clear?
Yes, sir. Absolutely clear, sir.
Okay. Now we come to the last question of the today's session.
So question number 30. Section 223, that is
you are not fully audible. You are not fully audible.
I'm audible now?
There's breakage of sounds.
So is it better now?
Ah, yes.
Better. Yes. So section number 13.
Yes.
Section 223 of BS, that is 100 feet.
Again sound breaks. Your voice breaks.
Audible?
You are audible, but your speech breaks.
Is it?
No, not yet.
Is it? So is it breaking?
Please read.
So, section 223 of BNS,
yes.
section 8 is cognizable as of one of
No. So? There is breakage of voice. There is interruption in the voice. There is your voice breaks. Why not I read it myself? Question number 13. Section 223 of BNS, corresponding to section 188 of the Indian Penal Code, is a cognizable offence as per part 1 of the first schedule to BNSS, that is CRPC. We notice that the schedule to BNSS shows which offences are cognizable and which offences are non-cognizable. Now, section 223 of BNS, that is corresponding to section 188 of the Indian Penal Code, is shown as a cognizable offence as per first schedule, part 1 of first schedule. So, a police officer is entitled to arrest the offender without a warrant, and there had been frequent clashes. That's in our fact situation. There had been frequent clashes between the Hindus and the Muslims on occasions when religious processions of Hindus were passing through a particular street where there is a Muslim mosque situated. A particular street, there is a Muslim mosque situated. There had been frequent clashes between Hindus and Muslims when processions of Hindus used to be taken through that particular street. Hence, taking note of this tense situation, the district magistrate had promulgated an order prohibiting religious processions by Hindus along the said street. Knowing fully well that there is a promulgation of such a ban, a Hindu religious procession comprising of 100 persons pass along the street, disobeying the directions of the traffic policeman on duty. It results in a riot. An FIR is registered against the violators. Now it is a cognizable offence as per the first schedule. After investigation, the police filed a police report before the magistrate concerned, charge sheeting the offenders for an offence punishable under section 223 BNS, that is section 188 of the Indian Penal Code. The magistrate, however, refused to take cognizance of the offence. Can the refusal by the magistrate be justified? That is the question. See, 188, section 188 of IPC, that is 223 of BNS, is a cognizable offence as per the first schedule to BNSS, CRPC. And in a case where such an offence was committed by a group of 100 persons, violating or disobeying the directions of the traffic police officer, traffic policeman, because there is already an order promulgated by the district magistrate banning Hindu processions along this street because of the frequent clashes noticed earlier. So, violating the ban and knowing fully well that there is a ban in force, a group of Hindu procession, a Hindu procession consisting of 100 persons proceed along the street, disobeying the directions of the traffic policeman posted there. And it resulted in a riot. Then the police registered an FIR and conducted investigation and filed a charge sheet. Charge sheeted all the offenders. Now, when the charge sheet was filed before the magistrate refused to take cognizance of the offence. Question is whether what the magistrate did is correct or not. Now, the answer is what the magistrate did was correct. No cognizance could have been taken on that police report because this section 223, section 223 of CRPC of BNSS corresponding to section 188 of IPC is an offence falling under section 215 clause 1, 215 subsection 1 clause A clause 1 of BNSS corresponding to section 195 1A1 of CRPC, where the court can take cognizance of the offence only on the complaint of the public servant concerned. The public servant, that is the traffic policeman who was posted on duty and whose direction was disobeyed, he alone can file a complaint and the court can take cognizance of the offence only on his complaint. Though this is a very rare situation where even though the offence is made cognizable, wherein a police officer can arrest the offender without a warrant, police cannot register an FIR, conduct investigation or file a police report. Therefore, this because it is treated as an offence falling under section 215 1A1 of BNSS corresponding to section 195 1A1 of CRPC. Now, that is it falls under the chapter. I'll read it for you. Precaution for contempt of lawful authority of public servants for offences against public justice and for offences relating to document. That is not relevant. So, precaution for contempt of lawful authority of public servants for offences against public justice. This is considered to be an offence against public justice. And the precaution for contempt of lawful authority of public servants is amount to contempt of lawful authority of public servant. And therefore, the public servant concerned alone can file a complaint and the magistrate can take cognizance only on such complaint, not on a police report. Even though it is a cognizable offence, the police cannot, supposing the police officer arrest the offender without a warrant, he will have to hand over the offender to the public servant, who alone can file a complaint before the police. In fact, the question was first considered by a 3-judge bench in Daulat Ram versus State of Punjab. Daulat Ram versus State of Punjab. AR 1962 Supreme Court 1206. AR 1962 Supreme Court 1206. Corresponding to 1962 2 Criminal Law Journal 286. 1962 Volume 2 Criminal Law Journal 286. 3 judges, Jail Kapoor, M. Hidayatullah, the author, and Raghubar Dayal. The same position was reiterated in paragraphs 27 to 30 of C. Muniappan versus State of Tamil Nadu, AR 2010 Supreme Court 3718. AR 2010 Supreme Court 3718, corresponding to 2010 9 SCC 567. Judges are G.S. Singhvi and Dr. B.S. Chauhan. Dr. B.S. Chauhan being the author. Again, the Madras High Court had occasion, the Madurai bench of the Madras High Court had occasion to reiterate the same view in Jeevanandam versus State, represented by Inspector of Police Velayudham Palayam. 2019, 1 MLJ criminal 36. 2019, 1 MLJ criminal 36, authored by Justice N. Anand Venkatesh. Justice Anand Venkatesh. And it's also by the Madurai bench of the Madras High Court. Then second decision is Abdul Wahab versus State, represented by Inspector of Police Tirunelveli. Tirunelveli Junction Police Station. Abdul Wahab versus State, represented by Inspector of Police Tirunelveli Junction Police Station. 2022, 1 MLJ criminal 646. Again by the Madurai bench of the Madras High Court. The author of the judgment is Justice M. Nirmal Kumar. Justice M. Nirmal Kumar. With that, we have come to the close of today's session. Now, have you understood the last question?
Yes, absolutely.
Yes.
Absolutely.
I am honored.
So we are honored. We're deeply thankful to you so much.
Yes.
So, in such a fruitful manner, in a very form, it has been truly enlightening and really interactive. So before we get to questions,
again, your voice breaks.
Is it better now?
No.
So before I was saying, before we move to questions, I would just, with your permission, like to quickly highlight our courses.
Yes. Oh yes.
So our flagship course, which is Judicial Services Examination course, and is as a B2B patient very kindly, and absolutely. So we have discipline, which is more structured. Will be 45 subjects which will cover. There will be daily classes, and they will be in the evening to accommodate the schedule, and we will try to cover the entire syllabus in about 8 weeks. Our special focus on language, GK, current affairs, legal GK, and it be there in this course. We're going to be getting notes, mentorship, and tests will be evaluated by the faculties themselves, who will be teaching that you have a very personalized approach. Each test will be encouraged. With this, also 1 year's subscription to LiveLaw as well. Keeping in that there may be commitments, we've also launched a site. It's a support and it covers 29 course subjects.
Difference between question 11 and question 12.
Same thing will be teaching both courses. Not get the notes classes for 1 month. You'll also have access to recording. Different comparison in front of you between J7 2.0 2.0 45 in J7 29 classes for the batches evening classes only weekdays to Friday. So 2.0 will be getting feedback session, weekly legal judgment discussion. The recording is going to be Jason. Only the test will be there, and to be able to access the recordings for a month. And I am thrilled to also say that for the course, we're offering 30% discount for today. Register today. This is discount. You can book the website. at www.law. I'll also be putting these contact details in the chat box in a minute. Email us, you also contact us on this number and further on the same. With this, I will take up questions now.
I find a question
Yes.
requesting the difference between question number 11 and question number 12. I will explain that. The difference between question number 11 and question number 12. Did not. It was been pointed out to me. Now, the difference is the information given to the SHO alleges the commission of a cognizable offence. Therefore, the SHO has to compulsorily register an FIR and conduct investigation. He conducts investigation and ultimately finds that the cognizable offence alleged has not been committed, but what has been committed is only a non-cognizable offence. He did not obtain the order of the magistrate under section 174(2) CRPC of VNSS because the offence alleged was cognizable offence. He was not expected to obtain the order of the magistrate. He could register the FIR, conduct investigation. But after investigation, he discovers that the offence committed is only a non-cognizable offence. Therefore, he should not be put in difficulty because he had proceeded validly. He had proceeded according to law. What Lalita Kumari versus State of UP says is that Constitution Bench said was, if the offence alleged is a cognizable offence, the SHO has no freedom. He has no alternative except to register the FIR and conduct investigation. So, as a faithful police officer, he registered the FIR, conducted investigation. But after investigation, he discovered that the real offence which was committed was a non-cognizable offence, not a cognizable offence. So, he should not be put in a difficult position. Therefore, the law comes to his rescue in the form of explanation to section 2D, that is 2D of CRPC, 2H of the BNSS, which says that if after investigation a police officer discovers that what has been committed is only a non-cognizable offence, then the report filed by him shall be deemed to be a complaint, and the police officer who filed the report shall be deemed to be a complainant, and the magistrate can take cognizance of the offence on that complaint. But in the other question number 12, the offence alleged was non-cognizable offence. Offence alleged in the information itself was a non-cognizable offence, for which the SHO had no jurisdiction to register an FIR or conduct investigation. He ought to have insisted upon the order of the magistrate under section 174(2) BNSS. Instead of that, he straightaway conducted investigation without the order of the magistrate, mind you, and reiterated. He found that the offence is a non-cognizable offence, which was the offence at the initial stage itself. Ab initio, it was non-cognizable. Therefore, there is no question of a police officer conducting an investigation without the order of the magistrate into a cognizable offence and then discovers that the offence is a non-cognizable. That is not the position here. Here the position was to start with, it was a non-cognizable offence. Therefore, either due to ignorance or mistake, he did not insist on the order of the magistrate under section 174(2) CRPC. Therefore, in such a case, the explanation to section 2H BNSS, that is section 2D of CRPC, will not come to his rescue. This is what the Supreme Court said, because the investigation conducted by him was without the order of the magistrate. It's a non-cognizable offence. So he should have insisted on the order of the magistrate under section 174(2) CRPC, which he did not obtain. Therefore, he had no jurisdiction to conduct investigation. Therefore, his report cannot be saved or salvaged by recourse to the explanation to section 2H of BNSS. Now I suppose you got the distinction.
Yes. If the person who's written this doubt still has an issue, it's a doubt. There's another question. Hello, sir. I'm second year law student. So, what is the big principle to differentiate between cognizable and non-cognizable offence?
Pardon?
Shiva Prasad is written, what is the basic principle to differentiate cognizable and non-cognizable offence?
That I already answered. Did you not
Yes,
listen?
the first question that sir took up.
Yes, cognizable.
Just read the answer. You can look at the schedule in the BNSS, the first schedule in the BNSS.
The framers of law, the lawmakers, have decided certain offences to be cognizable, certain offences to be non-cognizable. They have expressed themselves in the first schedule to BNSS, corresponding to first schedule to CRPC. So you can't question the wisdom of the lawmaker as to why a particular offence has been made non-cognizable, why a particular offence has been made cognizable. So it is there. The offence has been made either cognizable or non-cognizable. So we have to start from there. That is the basic distinction. If it is a cognizable offence, the SHO, if it is a information given to an SHO, he is bound to register an offence, an FIR. He has no option, no alternative. But if it is a non-cognizable offence, he cannot register an FIR, he cannot conduct investigation without the order of the magistrate under Section 174 to CRPC, BNSS, sorry. This is an unnecessary replacement of the old laws, time-tested old laws. There is so much confusion caused. See, one Evidence Act is more than a century and a half year-old statute. Even now you come across certain verdicts of the Supreme Court interpreting certain sections of the Evidence Act. So even now now a new law now has been substituted. Again there will be the litigation. You can take two more centuries for the litigation to come now. And even if any section required any amendment, that section could have been appropriately amended. The whole sections have been changed. So much confusion has been caused.
Absolutely.
Yeah. Another question, I think somebody has not understood the distinction between cognizable case and cognizable offence. Cognizable case means, I told you the answer lies in section 174, 5 itself, is it not? In section 174(4), where a case, see, there more than one offence can be committed in an occurrence. A person is attacked, there can be cognizable offences committed. There can be non-cognizable offences committed against him. Supposing in a particular case, in a given case, the offences committed are all cognizable offences, no problem then. Then if he submits an information to the SHO alleging all cognizable offences, the section itself, 173(1) BNSS corresponding to section 154(1) of CRPC mandates that the SHO shall register an FIR. Now a question may arise where one of the offences committed is a cognizable offence, but the other offence is a non-cognizable offence. If the other offence is a non-cognizable offence, the SHO cannot register an FIR or commence investigation unless he obtains the order of the magistrate under section 174(2). Is it not? But there the law says if at least one cognizable offence is involved, then treat it as a cognizable case and treat it as a case of cognizable offence. So if it is a case where 5 non-cognizable offences have been committed and one cognizable offence also has been committed, then it is a cognizable case, because there is at least one cognizable offence committed. So treat it as a cognizable case, in which case treat it as a cognizable offence. All the offences to be treated as cognizable offence. Therefore, with regard to the non-cognizable offences, the magistrate need not insist on the order of the SHO. Station House officer need not insist on the order of the magistrate, because law deems it as a cognizable case. Therefore, it is as good as a cognizable offence. But if all the offences are non-cognizable offences, you can't treat it as a cognizable case. Magistrate will have, the SHO will have to insist on the previous order of the magistrate under section 174(2) of BNSS before registering the FIR and commencing investigation. This is the distinction. I suppose you got it.
Yes. Certainly, sir.
Finally, say
Inquiry and inquiry.
Inquiry and inquiry is not a subject of today's discussion. Why do you ask that question? It's not a subject of today's discussion. It's a long subject. It's a very vast subject. Inquiry, trial, all those things. Distinction between inquiry and trial. Please confine to the subject under discussion.
Questions are more other topics which were not in discussion. If you have any other question related to today's session, they can ask.
Have you finished with the questions?
As I believe we have finished with the questions.
Okay.
So with that, come to an end to today's session. So we express our deepest gratitude to you for so generously sharing your insights and not just explaining what, but also why. To
Thank
each
you.
and every answer.
Thank you, Kritika. Well, in fact, you have beautifully compared today's session. Only thing is, toward the end of the session, your voice, there is some technical issue there. Please,
certainly, so I will look into this.
Please. Thank you.
It is both challenging and illuminating. We can't thank enough for your time.
Thank you
so much, sir. Thank everyone for joining in and for being great participants. If you have any questions, you can write to us, mail to us, or call us with your doubts. We'll certainly get back to you.
Okay.
Until next time, keep questioning, and most importantly, keep learning. Thank you so much, sir.
Thank you.
Evening ahead. Thank you everyone for joining in for today's session. I believe my voice was breaking towards the end. I just all of the messages, and I was actually at that time, I believe that you've seen the PPT that I was sharing. At that time, I was just talking about our new flagship courses. One is JSUP 2.0 and the other is JSUP. So we've launched these two courses. One is a full-fledged judiciary course, which is extensive, which is very exam targeted, and which is 45 subjects, which holistically covers UP, Haryana, Punjab, Rajasthan. All the state subject courses are covered in this course. And the other one is JSUP Lite, which is more suited to you if you are practicing, or if you want to just know all the laws this under your practice and everything. And you will not get notes in Lite, but in JSUP 2.0 you're getting notes and you're getting points. So let's say and this is in 2020. That is if you have any doubts, any queries, you can log on to the contact information, which I'm putting again in the chat box. There's a number, there's an email address, and there is our website. Yes, I will also put in all the citations in the WhatsApp group for today's webinar, if you've been unable to catch that. All right, everyone. Thank you so much. Have a great evening. Bye.